to set the table, Heather, I'm hoping you can give us some context, historical context for what led up to the passage of the Voting Rights Act in 1965.
Yeah, so this is one of the reasons I care so deeply about voting, is because the promise of the Declaration of Independence was that everybody had a right to have a say in their government. And that was, of course, when it was drafted in 1776, really limited to white men and largely white men of property. But that idea that a democracy depends on people's ability to have a say in their government is absolutely vital to American democracy then and now. And what we had in the American South from about 1874 to 1964, I'm going to take you only to there, was a system under which Black Americans could not vote. And a number of white Americans as well could not vote under that system, because there was essentially a one-party state entrenched in the southern states. And what happens is that after World War II, a number of presidents, both Republican presidents and Democratic presidents, recognized that this is not okay, that if the United States is really going to make a stand, first against fascism, as it did during World War II, and then against communism, as it did after World War II, it must itself embrace democratic principles. So immediately after the war, there starts to be an attempt of lawmakers to look at old laws and say, well, you know, Black Americans should be able to vote because of these old laws that are on the books. We just need to strengthen them a little bit. So under Eisenhower, we get the Civil Rights Act of 1957. And the idea was that it would strengthen civil rights and voting rights enough that that would be enough, but it really wasn't. So in 64, we get under LBJ, Lyndon Baines Johnson, a Democrat, the Civil Rights Act of 1964. And inherent in that Civil Rights Act, we tend to forget this now because we got the Voting Rights Act the next year, was the idea that people would be able to vote, that Black Americans would be able to vote, which they weren't in the American South in that period and had historically not been able to vote. But what happened after the passage of the Civil Rights Act of 1964 was that Black Americans started to try to vote. And interestingly, we don't hear a lot about this in our civil rights courses, but the people who were really organizing to enable Black Americans to vote in the American South was women, largely older women. And in Alabama, a woman named Amelia Boynton was organizing at the county level to get people to be able to vote. And she decided, this is 64, that the best way to call attention to her cause was to get Martin Luther King Jr., the Dr. Martin Luther King Jr., to be able to come to Selma, Alabama, where they were organizing to push the idea of voting rights. And this backstory is where we get what is going to become the Selma marches, because in Selma, people start to try to register to vote. And the sheriff, a guy named James Clark, basically says, not happening on my turf. And so he keeps arresting people. And a federal judge steps in and says, you got to stop arresting people. And so then he starts to use literacy tests. And in the literacy tests, no Black Americans can pass. Well, what happens then is that there are these marches in the area around Selma to try and enable Black Americans to vote. And a man named Jimmy Lee Jackson gets shot by police officers, and he runs actually and hides in a restaurant, and he dies in the kitchen of the restaurant. And there's such fury over the murder of Jimmy Lee Jackson that the civil rights workers decide that they're going to try and leech some of that fury out of the Black community by putting together a march to Montgomery, Alabama from Selma to emphasize the need for voting rights. And this is where we get the march to Selma across the Edmund Pettus Bridge, which was named for a former KKK officer, Ku Klux Klan officer, in which people like John Lewis were attacked by police officers and his skull was fractured. And Amelia Boynton is actually on that march, and she looks like she's been killed. At the time, of course, we now know who Representative Lewis was, but at the time, Amelia Boynton was the more famous of the two, and she is being held on the bridge like she's dead from being attacked. So after that, LBJ steps up and he says, we must make this cause the cause of American democracy. We must enable people to be able to vote. And the march continues from Selma to Montgomery, and they get to Montgomery on March 25th. And that night, a young white woman from Michigan is assassinated by the KKK as she is ferrying people away from the march. Her name was Viola Liuzza. And there is this sense that this is an American crusade to make sure that everybody can vote. And on August 6th, 1965, LBJ signs the Voting Rights Act. And I suspect the justice will be able to tell us what those pieces of the Voting Rights Act are that protected voting rights theoretically once and for all in the United States.
Yes, Justice Earls, please tell us what is in the Voting Rights Act, what was in the Voting Rights Act, and why was it so transformative?
Right. Well, I feel like we could spend actually hours on the history and what led up to the passage of the 1965 Voting Rights Act, and including from a legal perspective, there were lawsuit after lawsuit after lawsuit pre-1965 trying to vindicate the rights of Black voters in the South who were trying to register to vote. And I think part of the genius of why the 65 Voting Rights Act was such a powerful piece of legislation is actually illustrated in that movie, Selma, because what you saw was people on the ground organizing in the South, having direct connection to and conversations with members of Congress about what they were facing and what it was going to take for them to be able to actually register and vote. And so the lawsuits after lawsuits happened because lawyers would challenge one version of the literacy test, saying this is unconstitutionally racially discriminatory. There were prior Voting Rights Acts. They were saying these violate those earlier Voting Rights Acts, and the jurisdiction would just change the test a little bit. And so then they'd have to file a new lawsuit over the new literacy test. So what they understood was that it wasn't enough to just be able to go to court to try to get rid of these disenfranchising techniques, and understand there had been lawsuits prior to 1965 filed against the literacy test in North Carolina and other places. So the two most powerful parts of the Voting Rights Act are Section 2, which applies to the entire country and says that you can't have any voting practice, procedure, method, custom. You can't have anything involving voting that results in the members of a minority group having less opportunity to elect their candidates of choice. Then Section 5, which applied only to 13 jurisdictions in whole or in part. So that was mostly places in the South. The coverage formula was based on, so whether or not your state was covered, and North Carolina was only partially covered. 60 counties in North Carolina were covered jurisdictions. And that was based on what percentage of the voters were what percentage of Black voters were registered and had participated in the prior presidential election. And so it was a measure of how effective have these disenfranchising techniques been, and where in the country do we need to focus to eliminate them. And what Section 5 says is that you can't make a change affecting voting without getting either the Department of Justice or a local federal court to pre-clear it, to decide in advance that it does not have the purpose or the effect of discriminating against Black voters. So it was enormously powerful, not only as every change was supposed to be submitted to the Department of Justice. And we can talk a lot about how long it took for jurisdictions to actually comply with this law. It's stunning to me now how we kind of have pre-compliance is happening in our country, whereas with the Voting Rights Act, the law was passed. It took a long time for there to be compliance, but ultimately, between 1965 and 2006, when we lost Section 5, some 1,200 voting changes were stopped because of the Department of Justice saying, wait a minute, you can't do this. And that's everything from you can't move this polling place. You can't impose this dual registration system. You can't draw districts this way. Lots of different ways in which jurisdictions, you can't put in place a voter ID requirement that doesn't have a signature alternative. Lots of different laws that were objected to under Section 5 of the Voting Rights Act. And so it did two things. Not only did you have to get pre-clearance before you could put the law into effect, it switched the burden of proof. So instead of plaintiffs, Black voters, having to go to the courts and say this law discriminates against us, the jurisdiction had the burden of proving that the law was not discriminatory. And that then led them to do things like consult with the leaders in the Black community before they moved a polling place, so that they could report to the Justice Department. We have conferred, and locally leaders say this is not a problem. It brought transparency. So I started doing voting rights work in 1988, and every month I would get a list from the Department of Justice that told me every change across, I was working in North Carolina, every change across the state of North Carolina that had been submitted to the Justice Department. So I could get information about that change. You know, today there's much easier access than through the mail, but point being, you got a lot of information about what changes in voting were being contemplated. And of course, the thing we can't measure about Section 5, but we know happened, was the deterrent effect. So jurisdictions wouldn't pass a discriminatory law because they knew the Department of Justice wouldn't allow them. And you see things like when the day after the Shelby County decision, when the US Supreme Court said that this process, this whole Section 5 process is unconstitutional because of the coverage formula was not updated when it was reauthorized. The day after, the North Carolina legislators said, well, now we can go with the full bill. In other words, they had in their back pocket measures that they knew would be discriminatory against Black voters, and they knew they couldn't pass them and put them into effect as long as Section 5 was there. And once Section 5 went away, they could go with the full bill. And so then it took years of litigation for plaintiffs to prove that a lot of what was in that bill was intentionally racially discriminatory, which plaintiffs ultimately did, resulting in the decision from the Fourth Circuit, which said that North Carolina had discriminated against Black voters with surgical precision. So the law was powerful because it gave anybody in the country the ability to sue if they thought their rights, if they thought their ability to vote was not equal to everyone else's. But it also put a burden on jurisdictions. Almost, I compared it at one point to environmental impact statements. You had to show what the impact was on Black voters and that it wouldn't harm them, wouldn't make them worse off. And, to my mind, this was also in the Shelby County decision where in Justice Ruth Bader Ginsburg dissent, she said, throwing away this part of the Voting Rights Act was like throwing away your umbrella during a rainstorm because you're not getting wet.